Okay, let's dive right in and explore how a newly minted democracy actually navigates the incredibly messy transition between different constitutional eras, especially when fundamental human rights are on the line. Today, we are unpacking a really fascinating piece of constitutional history from South Africa, the state versus Sipho, Zakele, and Ntsele. Now, at first glance, you might think this is just a standard case about a guy in a field of illegal plants, but it's actually a masterclass in how a legal system manages the massive friction between cracking down on crime and upholding the absolute, non-negotiable bedrock rights of the individual. Imagine this for a second. Imagine being held responsible for a highly serious crime just because of where you happen to be standing, or what land you managed. That is the exact dilemma at the heart of today's case. If you're in charge of a piece of cultivated land and someone discovers marijuana, or daga as it's referred to in the source text, growing there, should the law just automatically assume you're a drug dealer? I mean, it sounds like a massive stretch, right? But for a time, that was the literal letter of the law.
We've got a deeply layered legal argument to untangle today, so here's our roadmap. We will start by examining the idea of being guilty until proven innocent. Then we'll move into the constitutional presumption of innocence, untangle a tricky tale of two constitutions, and finally, look at the ripple effect this all had on the justice system.
Section 1. Guilty until proven innocent?
The inciting incident here begins with our subject, Sipho Zakele Ntsele, who suddenly found himself in a magistrate's court convicted of dealing daga. But here is the kicker. He wasn't convicted because he was caught red-handed selling it. Not at all. He was convicted under the Drugs and Drug Trafficking Act 140 of 1992 using a completely bizarre yet highly deliberate legal mechanism that was specifically designed to make drug convictions much easier for the state to secure.
The actual statutory instruction embedded right into the text of the Act is wild. Section 21(1)(b) flat out stated that if daga plants were found on cultivated land and you were the accused in charge of that land, the law automatically presumed you were dealing those plants. Think about that. The state didn't have to prove you were selling anything. They just had to prove you were in charge of the dirt the plants grew in. And from that exact moment, the burden of proof shifted entirely onto your shoulders.
In legal terms, this law created what's known as a reverse onus. It relied heavily on a rebuttable presumption, which is basically an assumption a court takes to be absolute truth unless the accused can somehow jump in and definitively prove otherwise. It totally flips the justice system on its head. It makes the accused guilty until he can somehow scrape together enough evidence to prove their own innocence.
Section 2. The presumption of innocence.
So, how did the system correct itself? Let's trace how Ntsele's case traveled through three distinct judicial phases. Following his initial conviction in the magistrate's court, his case was sent to the Natal High Court for an automatic review. This is a crucial safety net in the South African legal system, meant to ensure that trial proceedings in lower courts are actually aligned with justice. Well, the reviewing judges took one look at this built-in presumption of guilt and immediately flagged it. They declared it invalid right then and there. But for a ruling that big, the case had to be kicked up to the highest court in the land, the Constitutional Court, for final confirmation.
Once it reached the Constitutional Court, Justice Kriegler took the lead on the judgment, and he hit the nail on the head, pointing out that this statutory instruction fundamentally breaks how courts are even supposed to work, by forcing judges to infer guilt from circumstances that don't logically support it, like merely managing a piece of land. The law introduces a terrifying risk. You risk convicting someone even when there is glaring, reasonable doubt about their guilt.
His crucial takeaway was that this mechanism is the absolute antithesis of the presumption of innocence, a right fiercely protected by Section 35(3)(h) of the Constitution. Justice Kriegler made it crystal clear. The fundamental rights wrapped up in the presumption of innocence are so vital, and the consequences of eroding them are so severe, that absolutely no societal interest, not even the very real need for effective drug enforcement, could possibly outweigh them. The law was inherently unconstitutional. End of story.
Section 3. A Tale of Two Constitutions. Well, actually scratch that. It wasn't quite the end of the story. South Africa at this exact time was navigating a massive transition from its interim 1993 constitution to its final 1996 constitution, and things got messy. Under the old rules, the High Court technically didn't have the jurisdiction to declare an act of parliament invalid. Only the Constitutional Court could do that. Under the new rules, the High Court did have that power, subject to confirmation later. The problem? It wasn't entirely clear which rulebook applied to Ntsele's specific timeline. If the interim constitution applied, the High Court's actions were materially defective, and this whole legal process would be completely aborted.
Thankfully, the transitional provisions in the new constitution offered an escape hatch.
There was a rule stating that pending proceedings should be handled as if the new Constitution hadn't been enacted, unless the interests of justice require otherwise. The Constitutional Court grabbed onto that rider. They stated it would be completely unconscionable to order the rearrest of the accused, and pure legal pedantry to force the entire case to start over from scratch based on a bureaucratic technicality. They chose to prioritize doing what was right over adhering strictly to an outdated procedural loop.
This brings us to a fantastic legal term used in the judgment, inchoate. It literally means something that has just begun and isn't fully formed. Because the High Court's initial invalidation was inchoate, meaning it had no real legal force until the Constitutional Court officially confirmed it, they technically couldn't overturn Nsele's conviction right then and there. But they didn't just leave him to rot. They ordered him released temporarily on his own recognizance pending that final confirmation. The Constitutional Court heavily praised this, calling it a sensible and exemplary course of action to prevent irreparable harm to a man facing jail time under a doomed law.
Section 4. The justice system ripple effect. You see, when a Supreme Court strikes down a piece of legislation, the shockwaves are immense. Justice Kriegler cited a very powerful idea from a U.S. Supreme Court case, Mackey v. U.S., to highlight the human cost and the absolute systemic danger of causing widespread dislocation. Think about it. If the court simply struck down the drug law retroactively with no guardrails, every single person ever convicted under it might suddenly demand a retrial or immediate release. The entire court system would be paralyzed overnight by fresh litigation on cases that were closed years ago. So the court had to draw a very strict line in the sand regarding retrospectivity. They ordered that the invalidation only applied to criminal trials where the verdict was entered after the interim constitution came into force, and where an appeal or review was still actively pending. If your case was already totally finalized prior to this order of invalidation, the ruling simply does not apply to you. It's a harsh reality, but winning a sweeping constitutional battle unfortunately doesn't magically unlock your cell door if your legal avenues have already been exhausted. Recognizing just how incredibly complex these decisions are, the justices essentially left behind an instruction manual. They laid out clear guidelines for lower courts dealing with constitutional invalidations moving forward. They emphasize that courts absolutely must evaluate evidence on systemic impact, they have to give notice to relevant state organs like the Ministers of Justice and Health, and they have to perfectly balance the need to give successful litigants relief against the need to avoid unnecessary chaos in the criminal justice system. Striking down a law is not just an exercise in legal theory. It is a profound, real-world balancing act of justice and practical government.
I'll leave you with this final thought to ponder about the sheer weight of constitutional law. The State versus Ntsele proves that efficiency in law enforcement can absolutely never be purchased at the expense of our most basic human rights. But it also reveals that repairing a broken law requires immense surgical care so as not to accidentally shatter the justice system itself. Thank you so much for joining me for this explainer, and keep questioning how your own legal systems balance the incredibly delicate scales of true justice.